From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court ends the week with three big decisions on the abortion pill Mifepristone, the legal standard for unions seeking court victories, and the legality of rifle accessories known as bump stocks. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. Supreme Court watchers are playing the odds now on opinion hand-down days as the justices wind down their yearly term and get ready for summer break. Last week brought some opinions, but only in knotty cases involving bankruptcy law and the arcane details of the federal estate tax. But this week, Alicia, has not been a disappointment. Let's start with one of the big opinions from Thursday. This is FDA versus Alliance for Hippocratic Medicine. It was a challenge to the Food and Drug Administration's regulations on the abortion pill Mifepristone, which the justices unanimously dismissed. Alicia, can you give us a sense of what this controversy was, what the argument was over Mifepristone, and what the justices did here?
So this pro-life group that representing doctors challenged the FDA's both approval going back to 2000 when the FDA approved this drug, as well as rules that it issued in 2016 and 2021 that eased the dispensing requirements on the pill. Namely, it allowed more healthcare providers, such as nurse practitioners, to prescribe the drug, as well as didn't ease the requirement that women actually go to the doctor to actually receive and pick up the drug. So it could actually be potentially prescribed by telemedicine. So the group, the pro-life doctors, challenged the approval and these eased of restrictions, saying that they were arbitrary and capricious based on the record of potential safety adverse effects. And what they also argued, and this is important in this case, is the threshold question of whether they have legal standing. And in order to bring a case in federal court, judges and then the longstanding requirement that you must show a concrete injury that you have suffered or are likely to suffer as a result of a defendant's action, and that the court could actually redress that injury or provide some kind of judicial relief. And in this case, the court actually just rejected the challenge because the plaintiffs, their claims as legal standing, and I'll go through those in a second, they said that those were basically lacked any kind of merit and would invite other kinds of legal challenges that aren't strictly quote-unquote cases and controversies. Now, their argument for why they had legal standing was that, one, that they could potentially be required to see more women or who had emergency abortions or needed emergency treatment, even though that they themselves didn't prescribe the drug. They also argued that if they were required to help or participate in these emergency abortions, that would violate their conscience rights. Now, Justice Brett Kavanaugh ruled for the unanimous court that, well, no, you provided no actual evidence that this could actually lead to more women actually going to the emergency. But let's say, even for the sake of argument, that it does, you provide no evidence that this could raise your malpractice costs or cause any other concrete harms. Now, for their argument about the conscience protections, the justices also rejected those basically out of hand, saying that, well, actually, federal conscience laws have always protected pro-life doctors from ever having to participate in abortions, and so that they do not have a claim that they can proceed with in federal court. So this basically knocks the case out, and they didn't actually get to the ruling on the merits of the pro-life plaintiffs' claims that the original approval or the easing of the dispensing requirements was arbitrary and capricious.
The standing rules are important to understand because you can't bring a case in federal court, Kim, over anything that the government is doing that you dislike. And the majority opinion here by Justice Brett Kavanaugh, I think, is pretty good on explaining the problem with these theories. Here is a key paragraph to my eye. He says, if we were to invent a new doctrine of doctor standing, there would be no principled way to cabin such a sweeping doctrinal change to doctors or other healthcare providers. Firefighters could sue to object to relaxed building codes that increase fire risks. Police officers could sue to challenge a government decision to legalize certain activities that are associated with increased crime. Teachers in border states could sue to challenge allegedly lax immigration policies. that lead to overcrowded classrooms, unquote. And the point here, Kim, is that that's pretty attenuated. You generally can't walk into federal court and say, I disagree with that decision that this local government official is doing or this federal regulatory body is doing, and that may increase the risk of some kind of fire. And because I'm a firefighter in this area and I might get called to that kind of fire and then I might be injured in that kind of fire. The point here is that that's not what federal courts do.
I like that Brett Kavanaugh took the time to spell this out for everyone. The doctrine of legal standing, which is this bedrock principle, is something that those of us who follow the courts know how seriously the court takes it. And lots of cases are thrown out because of a lack of standing. The courts take it very, very seriously. And so it was interesting. I think some of us actually watched the court as this case was pending. And when they were doing the oral arguments, the questions of standing were so profound. You could actually question why they took the case. But I think if the goal was to have the court unanimously come out and restate those principles, especially on a high profile issue, and this gets into the politics. This was not what the court was engaging in, but we have had a vicious fight in this country about abortion, and it continues in the wake of Dobbs. And this was an opportunity for the court to say, look, standing principles matter. It matters even in high-profile cases. I think it showed, it really, really sent a message out to folks that for all of those who claim that the court is all wrapped up in politics and that certain judges are using the court to advance their agenda. I mean, let's look at this. I'm sure there are certain conservative justices on the court who may not agree with abortion, and yet they told these doctors, you don't have standing to take down this FDA regime. And you probably had certain liberals on the court who support reproductive rights, a greater amount of reproductive rights. But the court all came together on a basic matter of law, explained why this could not be the case, the Pandora's box it would open. And I hope that a lot of people take the time to read the opinion on that basis.
Hang tight. We'll be right back in a moment. Welcome back. Alicia, how much was this result and the unanimity of it a surprise? And one thing that I think is important to point out is that the Supreme Court had previously, I believe last year, blocked a lower court order to allow the current Mifepristone regime to remain in effect while the case was litigated, which is sometimes a tell of how the justices are thinking about an issue. And yet it seems to me that there was another one of these panics by Democrats on the left about what the right-wing Supreme Court would do. You remember a recent term, there was one about whether the justices were going to get together to kill Obamacare on a technicality. And there was all sorts of headlines about that. And well, that didn't pan out either. And Alicia, am I wrong to see this as another example of the media and Democrats and people who are opposed to this Supreme Court fanning controversy? And then when it comes down to it, what we get is a unanimous ruling.
I agree completely with that. When you mentioned the Obamacare case, that was more than a few years ago now, there was much ado about that the Supreme Court was going to overturn Obamacare. And this was based on the Texas's lawsuit, basically arguing that Congress's repeal of or zeroing out of the individual mandate penalty basically meant that the whole law had to fall on this kind of a convoluted argument. But the question there was also whether the states had legal standing. And of course, you actually got a pretty large majority that ruled that no, the states, Texas does not have legal standing to actually challenge, to bring its case in court. For people who have actually been watching the court and reading their opinions, especially the conservatives, they'd understand that they take legal standing very seriously, and they're sticklers on this. I'd actually point out that the liberal justices have been much more flexible in these kinds of cases when there are partisan issues at stake. For example, the citizenship question on the census during the Trump administration, in which the liberals granted standing, said that the states could bring their claims on a very attenuated theory theory there. But the conservatives, again, have been very sticklers and have tried to maintain this line, in part because they don't want to be hearing and adjudicating all kinds of political disputes. Really, that's the role of Congress. And as Justice Kavanaugh noted in his opinion, these pro-life doctors are free to go and petition Congress, the president, the FDA to change these regulations. They can try to persuade their fellow citizens to lobby the government to do so. But it really isn't the court's role to step into this political dispute. And that's really important. I think that's why the conservatives have maintained their standing principles. And to your other question is this a big surprise? I don't think that this should have been a surprise to the liberals. I think that they tried to play this up in part because they're trying to undermine public confidence in the court, especially after Dobbs, and trying to bully the court in taking either more moderate rulings or not going all the way on some other important cases. And so it's really been a public campaign to smear the court. And if you noticed from some of the press releases that came out from the White House yesterday, as well as Kamala Harris and some of the Democratic AGs, they just kind of lied past the actual fact that they won this case and said, well, nonetheless, that reproductive rights are still under attack by Republicans and, the Supreme Court. And it was their quote unquote original sin with the Dobbs case that actually is leading to all kinds of restrictions on abortion. And so they're trying to spin this legal victory into a political defeat because it serves their own narrative that the Supreme Court is a bunch of Christian nationalists.
That political reaction that Alicia describes has indeed been fascinating. Let's listen to a clip of Senate Majority Leader Chuck Schumer yesterday responding to this ruling.
Though I am relieved by today's decision made by the court, no one should be celebrating this decision. This decision should have been an obvious one. And let us not forget, this decision was based not on the merits, but on a lack of standing. We are not yet out of the woods. This shouldn't be a decision women are forced to fear year after year, case after case. These healthcare decisions must be between women, families, and their doctors, not judges nor lawmakers.
Kim, I guess I understand Chuck Schumer's point that this was a ruling on standing, not on the merits, but he says this should have been an easy case, and it seems like it was an easy case. It was unanimous. What more did Chuck Schumer want from the Supreme Court here?
He wanted a political issue. That's what he wanted, and that is the incredible joke of the Democrats' reaction to this and really exposes the cynical politics behind this. They would have loved nothing more for there to have been a divided court that in some way, even one justice on the conservative side that cast doubt on this question about whether or not the FDA has the authority to dispense this drug in the manner that it is doing. Because they would have used it as they have used it as a campaign stick to flog on Republicans and scare the public, which is kind of all they've got right now, given the state of the economy and problems with their presidential candidate. But it's just a remarkable turnaround. We have heard now for months the wailing and the moaning. They pointed to this case of the court. See, Dobbs was just the beginning. They're going to take away abortion drugs, and then they're going to take away your contraception. They're going to take away IVF. This is a religiously motivated, activist, conservative majority that is on a tear. And then it comes out differently. And they're like, oh, you know what? That case doesn't matter. What matters is everything else. And I think it just really exposes how, as Alicia said, they are using the court as a political tool, a punching bag. They are not showing any deference or respect to this institution that really does need to have credibility. It does everything it can to maintain its credibility, but is under constant onslaught from partisan actors, particularly on the left, that see political value in tearing it down. They should be called out for that.